take much time for introducing. He's Professor of Anthropology and Director of the South Asian Studies Council at Yale. He's worked extensively in the areas of environment, anthropology, political modernity. You've seen the list of publications from the email announcement. His lecture today is titled Environmental Law and Ethics.
For inviting me to speak over here at Azim Premji University, and thank you all for coming. As Chandan mentioned, I'll say a little bit about the topic I'm actually working on only in the last couple of years or so. So, I spent most of my life doing research in forests and in remote agricultural areas. So this is a bit of a novelty for me to be working in an urban setting. Most of the research for this project is actually carried out in Delhi. And the reason for that will become obvious. It's both because that's where the Supreme Court is, that's where the Delhi High Court is, that's where probably the biggest concentration of lawyers is who fight environmental cases. And as I discovered, as I got more into this project, that's also a fascinatingly wide range of environmental litigation pertains to Delhi, as in everything from conservation of the rich forests something I know a lot about, to obviously air pollution and water pollution and toxic industries and relocation of displaced peoples by zoning regulations, and you name it, and every kind of environmental problem takes place right there in Delhi. So which also meant then that the widest range of cases pertaining to the environment are fought in the Delhi courts, especially if you think about the original jurisdictions through the Constitution in the Delhi High Court and of course the Supreme Court. So that's why by way of justification for the choice of field site. As an anthropologist, as you might have gathered, I don't just look at documents and archives, I do fieldwork, and fieldwork includes talking to litigants and people affected by these cases, but as much in this case also fieldwork among lawyers, fieldwork in the courts. I spend a lot of time in the courts watching the progress of various cases and the work of the green benches and so on. So anyway, with that preamble, let me get started with the paper itself. I'll take about 35 to 40 minutes. I want to make a few observations on the emergence of a distinct environmental jurisprudence and its relationship to the emergence of democracy in India. I'll draw, as I said, on my current work on courts and the environment. And the project, if I were to describe it in one sentence, would be something like how the environment came to become a legal object in India over the last century. And when you embark on such a study, how something becomes the legal object, I have to look at a number of things. I have to look at the making of law, the process of litigation, the formation of jurisprudence, and the relationship that develops between the legal public sphere and political institutions in the country at large. And of course, this means doing research, as I've said, in courts, in archives, with litigators and litigants, and with civil society organizations that are active in the legal public sphere. Now, I can't cover all this in a short talk, so in this particular talk, all I'm going to speak about really is just making a few comments on Indian democracy, followed by a very brief account of what I'm referring to as the making of environmental jurisprudence, specifically in the Supreme Court of India. And in constructing a sort of a synoptic account of this jurisprudence, I am actually deploying methods that I came across in the writings by actually a legal scholar who does not work in India, but who is a student of constitutional law, and Kim Lane Chappell, who actually now teaches at Princeton, and she describes it as constitutional ethnography, and that's sort of what this will be about, and we can talk a little bit more what that means. Now, colonial legal institutions for what are now natural resources or the environment have developed through the last decades of the 19th and early decades of the 20th century, and I'm going to suggest to you in two broad realms. One, which one might refer to as rural government, where such laws and their administration were most often directly in contact with the livelihoods and rights in land, in water, forests, animals, and other aspects of the terrestrial environment. The other, which might be called urban government, the contrast to rural government, was the realm where more often law and its implementation expressed ideas about public nuisance, about health, about sanitation, and less about individual or collective rights, but maybe more about civic sense and security, and also about pleasing vistas and how to live in planned cities. For instance, city improvement trusts, which were created in Delhi, Bombay, Calcutta, and a few other cities at the turn of the as the 19th century turned into the 20th century, so 100 years ago, they focused on hygiene and attempts to clean the city by segregation. In both these realms, environmental questions remain wrapped up or were anticipated in legal debates about how the government might provide essential resources for individual living and a social heritage or a public good. Now, the Government of India Act of 1935 and the Constituent Assembly debates of 1947 to 1950 added a new dimension to the development of ideas of the environment and how it might be governed by inserting them into other debates about the shape of Indian federalism. The Constituent Assembly debate on forests and public health are actually quite interesting in this regard, because in both cases the Central Ministry, Agriculture and Health respectively, argued that these should be placed on the concurrent list, that is, they should be made subjects where both centre and state could legislate. But in both cases the argument was made with the idea that environmental effects easily cross state boundaries. For example, floods or disease vectors travel with no respect to state boundaries. But their arguments were defeated, and the only case where limited success for central control was in the matter of interstate rivers and the control of pollution in these rivers. So what I'm saying is, by the end of the Constituent Assembly debates, by and large a lot of these subjects were left on the state list. And these were mostly debates about which level of government would administer what sector of the economy and society and be the prime mover in those sectors. And I think the effect of this distribution of responsibility that occurred with the formation of the Constitution in 1950 is with us till today. And you can see that in the legislative history of forests, for instance, since independence. Arguably, the Forest Conservation Act of 1980 and the Forest Rights Act of 2006 are both in their very different ways and in very contrasting intent, serving to abrogate powers that were vested in states by this separation that had been agreed earlier. The Forest Conservation Act did this in the name of central supervision of the process and purpose for forest land conservation for other public good. And the Forest Rights Act did the same in the name of ensuring local rights in forest land, especially for scheduled tribes, and that these rights would be effectively identified and protected and so forth. Anyway, the fortunes of federalism in the first 4 decades of Indian independence probably merit a more detailed consideration than I can offer you today. But if Granville Austin is correct in his assessment that the Nehru-Gandhi years saw an erosion of state powers in the right up into the late 1980s, with only some mild correctives applied by the Janata Party regime in the 70s, then the forest and environmental laws and its consequences simply grew from these processes and might have exacerbated what were really existing patterns. But apart from these aspects, the Constitution and its founding moments are also important for the distillation of aspirations. As Rajiv Bhargava has written, the Constitution is a touchstone, a moral document embodying an ethical vision. It envisaged nothing less than a revolution in several registers, the establishment of democracy and individual liberty, and the creation of conditions for emancipation of all kinds of subordinated groups and the achievement of equality by all. Now, these revolutions contained inherent contradiction, and they generated conflict between democracy and social revolution that often spilled into tension between legislative branch of the state and the judicial arm, which exercised the power of judicial review and enjoyed the role of guarding the core principles that were enshrined in the Constitution. The adoption of the Indian Constitution created a country of potentially equal citizens, all of whom remained within the national borders of the independent India. Now this required an elaboration of rights and also of governmental duties to bring about the social revolution that might be necessary for the effective exercise of rights, especially by those who were historically placed at the margins of society. It is thus useful to distinguish political rights from socio-economic ones, as the former are more readily part of the web of democracy, while the latter are the elements of this desired social revolution. Political rights might range from adult franchise to freedom of speech, and they may require governments to act as custodians. But socio-economic rights usually allude to the capacity and the conditions in which citizens can flourish, and this often requires government provisioning. Government actually has to provide that. The Indian Constitution distinguished between enforceable rights, which are protected by the incursions of states, and the non-enforceable principles, which were goals and duties the state might have to fulfill. And from the outset, the courts, that is at least the higher courts, the High Court and the Supreme Court, were situated at the very center of these aspirations that were released and the conflicts that were generated by this distinction. For they saw themselves as primary actors in facilitating a rights-based revolution that had been imagined in the Constitution. I know I'm being very quick and schematic here, but I'll risk saying that in the 50s and 60s, the question of rights, especially in rural government, was subordinated to priorities of national development, putting meaningful multi-level democracy somewhat at odds with macroeconomic development. So forests and rivers and common lands were legislated and administered on the principle that the first charge on them would be for national service. Equally, in the 1970s and 80s, much of these areas, and especially those where wild animals roamed, particularly charismatic megafauna, were claimed for nature conservation. Again, the question of rights was subordinated to other priorities, this time the preservation of national heritage. In some ways, the opposition between local rights and national heritage was even more marked, and is expressed quite vividly in the dissent that Valmiki Thapar wrote to the Tiger Task Force just a few years ago. And he wrote about the expansion of village rights and tiger habitats, and he said, these are his words, "The premise of continued coexistence over vast landscape where tigers thrive ecologically as well as people thrive economically is an impractical dream." So post-independence India also experienced a rapid expansion of planned development through these 5-year plans and significant central revenue outlays for local development through planned schemes that were sponsored by the central government. Democratic government in India was filtered through the institutions that were designed for planning with consequences for the environment inevitably. And so, both questions of rights and processes of planning became integral to the unfolding of Indian democracy. Courts entered this ferment through their own brand of activism, with the initiation of public interest litigation soon after the political emergency of 1975-1977, and they used their activist persona to focus on socio-economic rights and the quality of life. The judges began incorporating rights to health, food, education, shelter, and so forth into the fundamental right to equality and the life and liberty. So, Article 14 and Article 21. In their growing body of rulings, many originating in public interest litigation, potable water, clean environment, sanitation, all these became part of the right to life, while moving industries like stone crushing units or rice mills and brick kilns out of urban and residential areas was deemed crucial to its quality. In speaking of judicial activism, I should clarify that this term commonly applies to the power of higher courts to take suo motu notice of issues of public interest or initiate cases invoking their jurisdiction from the Constitution based on third-party complaints. But, as Nandini Sundar has argued, such activism is also more a characteristic of civil society in the last few decades than ever before. And in the interest of brevity, I will simply summarize as saying that legal mobilization is an important part of social mobilization in a way it has rarely been before. It's also waged across a broader terrain, including public demonstration, political parties and their need for votes, parliamentary committees, the media, signaling at once a more rights-based refashioning of the public sphere from below, as well as the way in which public participation is increasingly circumscribed by legal expertise. In a study of family law and minority cultural rights, Narendra Subramanian notes that legal mobilization increased among women's organizations, rights organizations, and community organizations since the 1970s. Women's organizations focused more on legal empowerment of women as they gained considerable influence over the legal elite and in the bureaucracies engaged in gender-relevant policy. Intellectuals associated with women's organizations became members of the Law Commission, the newly formed Women's Commission, and thereby pressed their demands. These organizations also attended more to litigation to urge the judiciary to grant women more rights, and many of them established legal aid cells to help women who were facing matrimonial problems. This led to the resolution of some of the disputes through informal arbitration in community courts and gave more women good legal representation if they approached the state courts. A similar commentary could be provided in the case of environmental NGOs and land rights advocacy groups, with the difference that they have actually been slower to litigate initially, but have become more wide-ranging and enmeshed in popular, often violent political conflict subsequently, as the construction of a legal and juridical public sphere around the quality of life has proceeded rapidly since the 1980s. Some environmental NGOs have been adept in recent decades when it comes to turning an issue with a very specific group and class interest into one of more universal environmental entitlements, usually expressed as the right to an ecosystem service or amenities in the public domain. It is to this sort of judicial history of this process that I would like to now turn for a brief delineation of how constitutional law was reshaped to produce what I will term environmental jurisprudence. Now, post-emergency Supreme and High Courts actually went to work with considerable energy on the expanded powers available from constitutional amendments and the climate created for the expansive interpretation of Article 253 and Article 21, the right to life and liberty. Judges in many states were inspired by the landmark Dehradun mining case and made the connection explicit by holding that the Constitution embraced the protection and preservation of nature's gifts without which life cannot be enjoyed. In subsequent rulings, the right to life and the right to livelihood were linked up. As the Supreme Court noted in 1985, any person deprived of the right to livelihood, except according to just and fair procedure established by law, could challenge the deprivation of defending the right to life. In Uttar Pradesh, the National Thermal Power Corporation was constructing the Raihan Super Thermal project, and land acquisition was made conditional on NTPC providing court-approved facilities to the ousted forest dwellers, who are mostly from tribal communities. So litigation benefited from the expansion of locus standi doctrine to include public-spirited citizens among those who might have standing to invoke the court on behalf of the socially disadvantaged individuals and groups. And the court established direct connection with citizens via the channel of fundamental rights and directive principle. The evolution of public interest litigation into a broad swath of social concern was facilitated by the growing availability, I think, of the environment as a foundry where the steel of progressive judicial review could be smelted. One keen observer actually traces the ascendancy of environmental subjects in public litigation as follows. She notes in its nascence, PIL was bonded labor, prisoners, child labor, the mentally ill, women in custodial situations. In the latter half of the 80s, environment began to occupy some place. In the 90s, environment came to dominate judicial discourse as a matter of public interest. As Charles Epp notes, a number of conditions in India seem to be ideal for the emergence of this rights revolution. Indian constitution guarantees a broad list of rights. The Indian state increasingly has come to violate many of those rights. Indians have used the language of rights in response, and the Supreme Court, after 78, has handed down a series of judgments that dramatically expand the scope of promised protection. The emergence of this tissue of varied rights is the more general context for the more particular examination I will take of environmental rights and how they came to be defined by emerging higher court environmental jurisprudence. As Michael Anderson notes, mobilizing existing rights to address environmental rights, interpreting existing rights to include environmental concern, and creating new explicitly environmental rights are all part of the same spectrum. There is also a vital distinction to be made between rights and standards. For the one may be allocated in principle, but the other has to be realized in practice and has to be realized for the right to be enjoyed. So without the standard, you can't have the right. Standards are harder to universalize and must respond to local perception and condition, including the possible implication for social conflict and exclusion. Despite the minefield of norms and practical legalities created by judicial endeavor to emphasize standards that respect the regime of rights that's been created, the movement towards jurisprudence, environmental jurisprudence, has for some scholars been inexorable. It has relied on constitutional law, rationale that places public over private interest, and procedural activism on the part of the courts, especially the Supreme Court. So what I'm trying to say here is that there is a certain rationale that emerges that puts public over private interest, but there's also a considerable amount of procedural ingenuity that's required on the part of the Supreme Court to make this work. By the mid-80s, protection of the environment and maintaining ecological balance, however you might define that, were being described as duties that were shared by citizen and the state. A series of cases took up issues relating to displacement of poor people from forests on account of large dams. And in a famous case of tanneries in Kanpur, discharging effluents into the river Ganges, the court actually gave itself the prerogative to issue directions to statutory authorities charged with preventing such degradation of the river. The argument offered was that while closure of tanneries may cause unemployment and loss of revenue, life, health, and ecological security have greater importance for the people at large in the vicinity of the river. In the protection of the river, that too one so closely associated with national heritage as the Ganges, the court argued not only from a logic of preventing or removing a nuisance, a common law reasoning that might be seen in colonial law, but also from a specific reading of Article 21, in which it noted that traditional culture and heritage and the protection of such heritage would come within the compass of an expanded concept of life. A few years later, the court amplified the right to life would include food, clothing, and a clean environment. The Supreme Court spent much of the 1980s expanding, standing, and enlarging definitions of the fundamental right to life to include natural heritage or pollution-free environment. The work reinterpreting the normative infrastructure of constitutional rights was accompanied by parallel procedural innovation to give practical substance to these principles. The new jurisdiction that created for the enforcement of fundamental rights enabled the evolution of procedure that was appropriate for the jurisdiction. The court found itself to be more than an umpire and cast itself in the role of the organizer of proceedings, a provider of relief, and the supervisor of the implementation of its own orders. To this end, it has become necessary to seek the assistance of expert panels, commissioners, advisory committees, and amicus curiae, of course. In 1991, a spate of cases brought both environment to the forefront and highlighted the procedural assertiveness of this jurisprudence. In one case pertaining to vehicular pollution in Delhi, a high-powered committee was appointed with a retired Supreme Court justice as the chairperson, and in others, drastic consequences were threatened for local authorities that did not implement earlier orders that prohibited quarrying in the Doon Valley and discharging effluents into the Ganges River. Now, by 1996, events had taken a different and somewhat more confrontational turn. The Supreme Court had taken interest in creating what I'm calling new state spaces involving institutional hybrids combining judicial oversight and executive accountability. A bench consisting of Justice Kuldeep Singh and Sabir Ahmed, acting on public interest litigation filed by S. Jagannathan, directed the central government to constitute an authority under the Environment Protection Act of 1986 and confer on that authority power to protect the ecologically fragile areas. During this year, 14 separate rulings closed factories that produced hazardous chemicals, relocated 168 industries from Delhi, banned mining in Haryana, introduced coastal zone protection in many states, fined tanneries in Tamil Nadu, and banned felling of forests in many other states, and took notice of the problem of air pollution in Delhi on its own. It is clear from these cases that the link between human rights and environmental rights the court was making was actually charted on two axes. One is the individual right, the right to life, and the other is a group right, like the rights of indigenous peoples to resources and self-determination in their native territories. So the emergence of public interest law took both indigenous conceptions of justice and cosmopolitan standards into the common law system received from the British. Both the responsibility of state to protect public interest and third-party litigation to identify such interests were clearly enunciated and allowed in the emerging category of public law. Nature conservation gained popularity in legal terms through eminent domain and public trust. But environmental law, often derived from property and tort law, to limit the exercise of private life entitlements to ensure they do not result in environmental loss. The human right to conservation requires the protection of the environment through a life of dignity and well-being, and various rights to life, health, livelihood, and cultural and economic rights are seen as contingent on the right to natural resources or nature in a larger sense. This shift has its own curious history in Indian constitutional jurisprudence. The Supreme Court actually started as a defender of property rights, inviting criticism for being a partisan of landed elites. And in traversing through this strong orientation in crafting public interest jurisdiction towards social justice, the court has fashioned an environmental jurisprudence that, to some at least, appears to be a vehicle of middle-class environmental values. However, to the extent that the construction of environmental jurisprudence rests on the constant negotiation of the tension between conservation and democracy, resources and amenities, livelihood and public health, ultimately envisioning intergenerational equity and the inhabitation of a planetary consciousness, the Supreme Court is actually called upon to struggle out of its own class affinities and contemporary pressures. In a 1995 ruling, the court was quite expansive. As it noted, the word environment is of a broad meaning. It includes hygienic atmosphere and ecological balance. Enjoyment of life, the court held, is not possible without the environment, and therefore air or water pollution and ecological degradation are a violation of the right to life. Realizing the obstacles to timely realization of these values, the court was looking all the time for mechanisms to translate judicial mandate into administrative action. It opined in the constitutional agencies for coastal zone regulation in both central and state government, assessed the environmental impacts of slaughterhouse mechanization, and in a case for banning the import, production, distribution of insecticides already banned in the US, it directed the creation of a committee from concerned ministries of the government to carry out the investigation. So the development of environmental jurisprudence is marked in the latter part of the 1990s by the adoption of various principles that further elaborated legal norm beyond the expansion of standing or fundamental right and procedural flexibility or administrative engagement of the court. Responding to a news item in the leading English daily published from Delhi, the Indian Express, the Supreme Court took note of a matter concerning a private company called Span Motels that had built a club on the banks of the river Bias, encroaching reserve forests. This case led to the extension of the public trust doctrine for environmental protection. The court observed that while public trust under common law only applied to traditional use like navigation or commerce or fisheries, American courts had actually used this doctrine to protect ecological values like fresh water, wetlands, riparian forest. So based in its English law heritage but adopting American innovation, the Supreme Court ruled that the environment and ecosystem cannot be permitted to be eroded for private use unless courts find it necessary for public purpose. So the National Environment Research Institute was a public sector institution, was asked to evaluate the damage caused by the Span Motels, and they were required to pay restitution, while the state government was held to have breached public trust. In another case, where the Lucknow municipality of Mahapalika allowed a builder to construct an underground shopping complex, the municipality was found to have deprived the residents of the area of historic park and thereby violated public trust. Along with public trust, the court also began to rule on something called a precautionary principle as a way to clarify the relationship between the fundamental right, fundamental duties, and the directive principles of state policy. So the precautionary principle could be invoked when 246 kilns in the Union Territory of Delhi were ordered closed while the local administration was asked to assist these kilns to adopt pollution mitigation technology or relocate to other areas. In some ways, this principle enables a proactive policy to prevent the violation of public trust. So, for instance, in a case pertaining to sanitation in Agra city, the court not only held the government responsible for supplying safe drinking water and sewage, but also constituted a committee involved social workers and civil society organizations working with the Divisional Commission of Agra to estimate the effectiveness of the municipality in actually delivering these services. The precautionary principle, the court observed, and the corresponding burden of proof on the person who wishes to change the status quo applied in cases of polluting industries where the extent of damage may be hard to assess, but where environmental effects can be estimated through impact assessment and other prescribed mechanisms under rules framed under the Environment Protection Act, the principle of sustainable development may come into play. So you can see yet another transition here from the precautionary principle to a principle termed sustainable development. Sustainable development principle was articulated as a way to find a reasonable path between conservation and development. The court was emphatic in noting that awareness of the fullest implications of environmental destruction need to be raised, and one way to do this was through yet another principle, and that was the one known as polluter pays. That is, polluters not only pay the damages for the restoration of what they have destroyed, but they also compensate citizens for suffering losses through ecological disturbance in their lives. Now, I've run through very quickly a series of principles from all the way from expanded standing through the polluter pays principle to give you a sense of the scope of development of environmental jurisprudence in just a period of about 20 years. As I conclude this necessarily short and selective discussion of cases relying both on common law and rights-based innovation in the US, I'd like to point out that the court has also been alert, when it has been possible, to classical guardianship functions of core values, even as it evolves new innovative jurisdictions. So, for instance, in a case relating to noise pollution caused by the use of amplifiers in religious services, the court held that the rules under the Environment Protection Act, which specified that such noise pollution was a hazard to humans and animals, was entirely reasonable, and they created this by linking it to, they created this possibility by linking it to colonial and nuisance police laws. Similarly, in matters pertaining to pollution in Delhi and the inaction of municipal authorities, the court reiterated compliance with existing provisions would serve the articulated environmental protection. So it looked to even colonial municipal and cantonment laws as providing it with the basis for the rulings it was making almost 100 years later. In 2000, an important order further clarified the role of the court in environmental protection and elaborated jurisprudence on sustainable development. It ruled that where an attempt had been made by the state to balance the need for environment and economic development, and impoverished areas are likely to benefit, it would not be proper to apply a principle of absolute prohibition. Rather, principles of protection, polluter pays, sustainable development, and intergenerational equity should be applied. Ranging across a stream of emerging environmental principles, by 2000, a number of cases listed as environmental had grown dramatically. The Supreme Court was reserving Fridays for environmental litigation alone to deal with these cases. And 10 years later, in 2010, when I spent quite some time in the courts myself, I found that these green benches were now sitting both on Mondays and Fridays, recognizing the growing volume and justice-confounding delays of these environmental cases. In contrast to the account that I've sought to provide of emerging principles that might have shaped an environmental jurisprudence resting on public interest after 1980, much of the commentary on judicial activism has actually taken the path of describing the inevitable expansion of judicial review and the consequent flood of court direction and public policy plagued by government inaction. These are the words that can be found in the analysis of noted jurists like Krishna Iyer, Nurani, or Madhu Dandarakar. It would appear that they are concurring with Atul Kohli's analysis of the powerlessness of proliferating government institutions, and some of them also describe the heightened activism of the 90s as a temporary phenomenon that responds to acute crisis of governance in the post-liberalization era. I would like to bring this question into the light of two other perspectives. One taken from political theory considers the relationship between constitutional law and democratic politics. As Sunil Khilnani notes, meditating on the multiple meanings of political representation in India since 1950, in the early 1950s and again in the 1970s, the issue of equality was focused around rights to private property. But since the brief episodes of radicalism in those periods, the issue of equality has moved to a different arena, addressed through reservations and other kinds of group identity based, including women, tribes, Dalits, religious minorities, and so on. In fact, as Ramaswamy Sudarshan has reminded us, with the abolishment of the right to property from the fundamental rights in 1979 by the 44th Amendment, certain impatient identity politics may be present in new social movements and gained acknowledgement. It is to note here, of course, that the people who pioneered public litigation like Justice probably did not share these anxieties, so they did not see a gap between an earlier constitutional pursuit of equality and a more critical pursuit of equality that came later. Other perspective that I'd like to place this question in light of is that of Indian feminist scholarship. There is now a very interesting debate on the place of judicial activism and concomitant casting all issues in the rights framework when it comes to securing the well-being of women in all situations. Litigation to develop more specific legal instruments or to make bureaucratic delivery more accountable is not seen as something as the solution. There is an interesting debate among feminists about the efficacy or even desirability of judicial activism in securing the rights of women. Feminist theorists and activists have questioned the wisdom of allowing liberal state ideologies to express themselves in the language that has been crafted and made legitimate by years of struggle in women's movement. Should environmentalists have the same worries? Does judicial activism rely on the enterprise and commitments of environmental justice movements reformulating environmental questions in terms that might be co-opted by the state? What role can metropolitan civil society play in the struggle between quality of life and that has been articulated by the growing middle class and the right to livelihood for most poor people who have been driven to the wall by private public, civil society and state formation, and I hope to be able to offer much more on these topics as my own work moves forward through a study of litigation in and around the Delhi area. Thank you.
Happy to take a few questions.
Yes.
The dynamics behind it.
Or bench hunting, or looking to a particular bench to get a case.
Then to it, there are other issues like a lot of NGOs which have come up with that. And I remember in the Kalyaneshwari case itself, the CJI himself said, has issued contempt notices against the people who came up with this. Though he issued directions with regard to investors and everything. So, how do you correlate the two?
Yeah. Well, since I've been looking mainly at the Supreme Court, and in the Delhi High Court, the Chief Justice has constituted the bench for the public interest cases. And so as long as the public interest case it goes before the PIL bench, which is the Chief Justice, which may or may not include an additional judge. The Supreme Court, the Green Bench, now there are two, and that's only since 2010. But with the two that are now there, one of the benches is again chaired by the Chief Justice and has one other member. And the other bench has two other members, but it's rotated. Every few months, two different judges occupy the Green Bench. So, at least in the Supreme Court, which is where they have the specific environment-related benches, I get the sense so far, under Justice Kapadia at least, the idea has been to get a variety of judges acquainted with the problems of the environmental cases. On the second point, one of the interesting things about these cases is that they are not adversarial cases. That is, it's not party A against the state or party A against party B. And while they may initially be brought by somebody like an NGO or some public spirited individual, at some point they become part of the court's direct jurisdiction. So what happens is it becomes, the court takes upon itself the responsibility of settling this matter to its satisfaction, and that is why other vehicles which I was referring to become very important, like who is the amicus curiae and how expert they are and how well they're doing their job, or what kind of court commissions are being appointed and how seriously are they being taken, what powers are being vested. For instance, this committee that was appointed in 2002, the CEC, was initially considered not very effective, but courts devolved more and more powers to them, including powers of inquiry, including powers of dealing with minor points that need not come before the bench, and they increased the power of that committee. Now it's a administrative quasi-legal body, but it's appointed by the court, it's the powers of the court. So what I was trying to say was it's as interesting in these cases to look at the constitutional or the legal issues themselves as it is to look at the procedural innovation the court is engaged in all the time to try and expedite these matters, and in the process to develop this jurisdiction that I'm referring to as the environmental jurisprudence.
To that last section that you discussed about feminism and whether law is enabling at all and so on and so forth. Because your title suggests there's a connection between democracy and environmental law, but the story is about the courts, which of all the institutions is the non-democratic one. So if the story is about a legal evolution, I was struggling to find the connection to democracy as such. So that was one. And the second thing that I had in mind was the chronology. I know that the standard chronology of the Indian court story has this sort of predictable 60s, 70s awakening, some 80s maturing, and some 90s decline. I'm curious about that chronology. My sense of even environmental cases in the way they were litigated earlier might be in the land revenue courts, not in the High Court, not in the Supreme Court, but very intense struggle over pastoral lands and those kinds of issues in the land revenue courts, which may be in some senses the unglamorous side of the legal system. But that story is there already. So I'm just curious about how we work these chronologies. What about the 80s? Is it Kuldeep Singh that's important? Has in that sense, Harish Salve claims that he's saving the environment. Is that true? While they may have 2 green benches or 3 green benches, that's not quite the story in some ways. And the other, a third kind of line that I was following and trying to get a sense of is the green bench story and the range has a very interesting institutional story, both of excess and of the way kinship works. So when I think about environmental law as a lawyer, what strikes me most is how few people participate in environmental litigation. How is it that MC Mehta emerged? Even as a student, we were amazed at how one person could file so many cases about just about anything. He could file a case and it would be admitted and action taken at the... So in a sense, I find that stories about environmental litigation in India seem to tell an institutional story, whether it be of the precautionary principle, legal doctrine, or how has the Supreme Court evolved. But there is a certain sense in which the thickness of description we're losing, and there's a very interesting story there. Because environmental litigation is peculiar, even by Indian standards. Someone needs to really tell that story. How did Kuldeep Singh get that leash? We can't think of any other judge in any other sphere. Like if you were to press me to name an administrative law judge who did as much. There isn't one. So I think there's a great institutional story of personalities and actors in this. But I don't know if that's the kind of story that you're interested in, or maybe it's a part of your wider work.
No, these are all good points. As I mentioned at the outset, there are those elements of the research are also there. They're not reflected in this particular talk or this particular paper. And as far as again, I'm not pursuing this particular project in lower courts at this point. And the extent to which land revenue courts have actually ruled on matters which might be considered environmental is, there's lessons to be learned there. At the same time, there's also a limited understanding because they are largely to do with land rights. Whereas here we're talking about the emergence of the environment as a social and legal concern, something to do with cleanliness, pollution, enjoying the nature as a value that is good for the soul and good for the body in so many ways. These are values that are peculiar to our times. It would be somewhat anachronistic to see these values circulating in society, even in elite society, say 60, 70 years ago. And so that's on responsibility of first point. And the chronology issue, I agree with you that a lot of the self-congratulatory writing on the evolution of the courts tends to follow this experimentation to maturity narrative. But what I'm actually trying to look at is the way in which certain sets of very different chronologies parallel each other and create moments of historical conjunction for certain things to emerge. So, to me it's no surprise that there is a large explosion of such litigation in the period after the emergency and even more so after 1986. Because in a sense, the previous 10, 15 years, a lot of time was spent creating the infrastructure of law itself, right from probably the Wildlife Protection Act of 1972 through the Environment Protection Act of 1986. So there's a 14-year period, and there's a slew of laws which can be seen as explicitly environmental laws. The Clean Air Law, the Clean Water Law, the Forest Conservation Act of 1980, and so forth. So you get a series of these laws which begin to create a legislative domain called the environment in much more clear terms. Because if you look at before 1970, there are of course battles being fought both in the higher courts and in lower courts, which we can now read back into them environmental content. But we can only do that from the vantage point that we occupy today, because what they're really dealing with, they're terming them public nuisances, or they're terming them workplace safety issues, or they're terming them labor issues, and so forth. But what in effect they're often tackling are environmental issues. And I think the environment becomes more of a concealed agenda, more of an explicit agenda, only because the legal armature is created for it in the later period. And so there's a historical conjuncture, I would say, between making these laws and a certain turn that the courts take around the same time, some of which has been explained as a phenomenon related to the crisis in democracy that occurred in the mid-70s and so forth. Now, so the courts are the most undemocratic end of the spectrum, you mentioned, yes, and that looks increasingly more so now. If you try to enter the Supreme Court or now the Delhi High Court, it's so hard. I can see how it's like a fortress. It's hard for anyone to get in there, let alone plead their cases or be present when their fate is being determined. But for my own project, that's not the end of the story. I am working with litigators, I'm working with specific disputes where I'm doing ethnographic work with people who are affected by these cases and so on. So it's only one part of the larger puzzle. But even if that were not the case, I mean, the courts are, at some level, one piece of a larger democratic framework that was created. In essence, that's why I spent a little time in the beginning of the paper talking about the separation of powers, both in sort of federal sense, in what the central government can do and what the state government should do, but also a separation of powers across various arms of government. And that was part of the constitutional vision of democracy. And the courts definitely had a place in that, including being the guardians of those very core constitutional principles, which were, in a sense, the cornerstone of democracy. Fundamental rights as the cornerstone of democracy, and they were the guardians. So, however they function, however undemocratically they can actually function in the day-to-day functioning, they are cast into this very crucial role of guarding the most basic rights granted to citizens. And to me it was a curious evolution that it took a spate of environmental legislation for them to become aware of the expansive scope of these rights. I mean, people are arguing now, of course, that they have taken things too far, that everything cannot be linked to the right to life. But nevertheless, they took that turn in the last 20 years or so, and the vehicle for that was mainly environmental cases. I mean, you're right, a handful of people file those cases, and MC Mehta probably files more than half the cases, up to a point. But now when you look at the more than 1,000 cases that have accumulated, and I've made a database of more than 1,000 cases, MC Mehta is not 500 of them. He was at one point probably 3/4 of the cases, but no longer. And what is curious about that is more and more environmental cases dominate this particular public jurisdiction. So they have become the vehicle for whatever reason, and it needs explanation. Why do they seize the imagination? Why does environmental litigation become the vehicle through which we are conducting this fundamental inquiry into the nature of rights? And so that's a question I'm asking myself. I don't have an answer to it. And I'm saying that people involved in the feminist movement have sounded a cautionary note. They have said that they went down that road and they're not entirely happy about it. And I'm wondering if the environmental folks should have the same concern or not. But for now, they don't seem to. They, across the spectrum, they're using the courts. And so it's not just, a handful of people in Delhi. I mean, people fighting POSCO in Orissa are fighting these cases. People fighting for stuff in the Northeast are fighting these cases. So a very wide range of people maybe doing a range of things to fight their respective struggles. But one of the elements of their fight is almost always a PIL as well. And a PIL that's built around this question of fundamental rights somehow. So in that sense, the rights discourse has really become this great vehicle of hope, especially when it's built through the environmental theory. That's sort of what I was. And as I said, a lot of this has raised questions for me, which I've yet to answer. But so some of it was speculative or requiring further exploration. At the back, yeah.
Emerged in India in the 70s and 80s, and you largely grew upon several cases at Supreme Court and Delhi High Court level, as you said. But what appears to me is that during mid-80s, as environment clearance processes are put in place, and with notification, EIA notification 86, and the several amendment to that in 2006 and onwards, the way several other judicial arenas were opened, for example, for appellate, for communities that were grievanced by the clearance granted to certain project, they could have gone to National Environmental Appellate Authority. An authority that didn't have a publicly visible address, that didn't have a website in the era of this, and an authority that actually entertained very few cases and disposed them off on technical grounds, several times saying that case didn't come before us within 90 days of clearance being granted and things like that. So I think there is a lot of scope of engaging how NEA function and the way the death of NEA was pronounced by bringing up this novel judicial institution called New National Green Tribunal. And it remains. Now National Green Tribunal has started listening, hearing certain petitions, and they have started even passing certain orders. So it still is quite premature to judge how NEA has functioned and how different NGT would be. But I think the project that you are talking about would be looking at certain of this sort of institutions. You definitely mentioned about CSC. Initially there was this view that CSC was very conservation oriented and at times pronounced certain recommendations in cases like Jambu Fisher Folks eviction case that went against people. So I was curious to see if you are drawing from NEA's experiences and
you're right about NEA. In fact, as you say, the National Green Tribunal, it remains to be seen if it can take failure is precisely for the reasons you mentioned, that as long as it interpreted its role in a narrow bureaucratic sense, it was not getting to the heart of the problems. And the ball was repeatedly returning to the court of the Supreme Court under its original jurisdictions, because these are fundamentally questions about people's futures. I mean, could they live or die? It was as basic as that. And the NEA was not, I would say, not even empowered to address such basic questions. And going back to your earlier point, yes, of course, the 86 Act, it took many years, more than 10 years, for it to be fully developed through rules and standards, developing and standards, evaluating organizations like pollution control boards and so on. But once such entities came into existence, the bureaucratic apparatus for enforcing the environmental law was more or less in place. And environmental impact assessment began to be a more regular procedure. It led to a whole range of disputes over procedural matters, which, in fairness, could have come before NEA, but they did not. So, failure of NEA is a case study in itself, which probably has to be done. And you're right about that. But hopefully the National Green Tribunal will reduce some of the demand for the time of the Supreme Court and allow some of these matters to be decided in a more timely fashion, which is ultimately the most undemocratic situation, is that these matters don't get decided in a timely fashion. So the grievance, becomes extraordinarily large and unbearable simply by virtue of delay. And that hopefully the Green Tribunal might be able to address, but we don't know that. There's a hand up there somewhere. Yeah.
Up to what extent in the hands of local governance body or provide them liberty or right to protest against the coercive acts of state or union government? They are sometimes forcing to establish ministries in anywhere. So what kind of laws they have, local governance have, to protest against these kind of coercive acts?
Yeah, well, there's two kinds of things. I wish that were the case. I wish that usually they are not. But yes, the environmental impact assessment process is a process where I think state governments could bring that opinion to bear, could bring that perspective to bear, and say that certain projects are poorly conceived of in terms of the environmental impacts, and therefore, since they will deal with the brunt of the impact, local governments are left with the project, with the task of cleaning up. Once a particular project is implemented, in terms of displacement of people, pollution, various things, their local government ends up dealing with all the problems. So EIA is a great opportunity, but so far I have not really come across an instance where state governments have drawn on the EIA process to present their point of view. I mean, I have seen some new research or a student who's working with me in part is doing on EIAs in Northeast India in connection with the micro-hydel projects. But it's not clear to me that the state governments there are seeing the EIA as an opportunity to resist these stands, if they find them to be unsound, which they do. There are mechanisms available, especially with the elaboration of rules under the Environmental Protection Act, that state governments could use, but so far I don't see much evidence of that.